My Lords, before I move to address my amendment, I would like to express to your Lordships complete support for this bill. I had the honour to be a member of the Special Bills Committee, so ably chaired by the noble and learned Lord Thomas, and I sat through all the hearings and sat and deliberated with my co-members of the committee throughout our deliberations. My Lords, that perhaps I could do no better in expressing my support for the bill than to quote from the explanatory notes, paragraph 6. It reads as follows: "The intent of this bill is to further the principle founded in Section 1 of the Arbitration Act 1996 to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. Thereby the aim is to fulfil the policy objective of ensuring that the Act is fit for purpose and that it continues to promote the UK as a leading destination for arbitrations." My Lords, I now move to my amendment, and as I do so, I would like to express thanks to my learned friend, the Minister, my noble friend, the Minister. Unfortunately, he doesn't take the learned with his name, although he is very learned. And I'm very grateful to the Minister for his letter to me of the 15th of August on the corruption issue, and I read the entire contents of that letter and express gratitude without reserve. But I'm afraid to tell your Lordships, for reasons that I will now develop, that the reply in this letter is not complete. My Lords, first of all, I think we must look at the extent of corruption, and I'm afraid it's bad news. There's the Nigeria case and the judgment of Robin Knowles, Mr. Justice Robin Knowles, on the 23rd of October 2023. And nobody in this committee knows more about that case than the noble Lord Wilson of Tredegar QC, who took the role of a senior counsel throughout the long hearings before Mr. Justice Robin Knowles. The fact is, however, my Lords, that in those arbitration proceedings resulting in the case in front of Mr. Justice Robin Knowles, there were two very distinguished English arbitrators, former judges of the High Court, who made an award, a very large award, of US dollars 11 billion. And because of the corruption that was found by Mr. Justice Robin Knowles, that very large award had to be set aside in its entirety. Moreover, my Lords, this is not the only case where corruption has evidenced itself. There is the charity under the title of Spotlight on Corruption, and they have identified 3 recent cases in which serious corruption was found. There's the Mozambique case before the UK Supreme Court in September 2023. There's the Steinmetz case before the ICSID Tribunal in Paris in May 2022, and the BSG case before the LCIA in April of 2019. So this is a serious problem, and I remind your Lordships of what I said at second reading in this House, that I myself have had experience as an arbitrator in commodity arbitrations relating to Ukraine and Russia, where corruption was most evident, often just to the bribing of officials to obtain export licenses. My Lords, facing all of this, I'm offering a very simple measure which will show the international community that corruption or fraud in all arbitrations where the seat is England are quite unacceptable. It won't stop corruption in arbitrations, but it will be placing, as it were, a firm flag in the ground. How will it work, my lords? What should the arbitral tribunal do? I know if I was sitting as a chairman of an arbitral tribunal or as a sole arbitrator, that at the very commencement of the arbitration, when traditionally the arbitral tribunal draws together both all the parties and all the counsels to settle the terms of the proposed arbitration. And I would then say to counsel in the hearing of the parties that in the dispute between that there should be no tainting in the dispute before the parties of corruption and fraud. I know this from my days as counsel and solicitor. When counsel or solicitor are taking instructions from a client and preparing witness statements, there's plenty of opportunity to smoke out potential acts of corruption and fraud. This, I suggest, should be addressed now not in some distant opportunity for arbitral reform. As I said in second reading, I've been involved in arbitration law reform for a very long time, actually since 1978, a period of 46 years ago. And if we look at the distance in time between the 1979 Act, for which I had a lot of responsibilities, to the 1996 Act, in which I also had responsibility, that's a period of 17 years. And if we look at the period between the 1996 Act and now, that's 28 years. So it is essential, as I suggest, we address this issue now in this bill. Now, I know the Minister is rightly anxious to get this bill without delay onto the statute book, and I commend him strongly on that. But there won't be any significant delay, I suggest. There's a hand movement from one of the whips. I'm just wondering if it was addressed to me. Apparently it's not. The reason why I say there will be no significant delay, what I envisage, therefore, if the Minister will assist here, is that this very simple amendment is sent before all the bodies that appeared before the Noble Learned Lords Thomas's committee, and each of those parties, that's to say the Chartered Institute of Arbitrators, the London Court of International Arbitration, the ICC and so forth, should have an opportunity to express their views. I know that following Lord Bellamy's request when he was the Minister, that letters have been sent out and received in reply to the main institutes on the issue of corruption, but that was in a wide remit. This is a very precise and small remit, namely the wording of my amendment. And my lords, that it won't be possible, unfortunately, for Lord Thomas's committee to meet up again, but the answers can be easily obtained if my lady friend, the Minister, could kindly help. And then the House will know within a month of what responses we get are received upon the drafting of my amendment. Above all, could I ask the Minister, my noble friend, to have an open mind, that as far as we know, unlike last time, this government is under pressure. There's no danger of a sudden dissolution of this government. So there is time, my lord, to make proper inquiries on this. And so this, what I suggest is a very important amendment, is included in the bill. I beg to move.
A member proposed after clause 4, insert the new clause as printed on the marshalled list.